One of the kinds of claims that we are often retained on involves someone falling and hurting themselves because of dangerous conditions that were allowed to persist on any given premises. It can be outside the home or it can be inside. Often it involves someone being in a store. So we were called by a fellow that I'll call Tom, who was shopping at one of the local department stores. It was about 5 minutes before closing. He wasn't in any particular rush. And while he was completing his shopping, he encountered, unbeknownst to himself, some brightly colored liquid which had spilled on the floor of the department store. He slipped on it, he fell to his knee, and injured his knee badly. Now, he didn't know it at the time, but he'd actually fractured his knee. The bone is called the patella. He went on to have surgery, developed chronic pain, became very depressed, and was off work for a considerable period of time, but was able to return to work eventually. He was a hospital worker. Every case seems to have what I call warts. These are things that make a case less than perfect. And there's a variety of warts that exist on files. In this particular case, which is often true, the pre-morbid health, or the health of the victim before the accident, was relevant to how the victim responded after being injured. The family doctor, for example, wrote a report indicating that Tom had never had any problems medically with his knee before the accident. So you can imagine my surprise when I obtain full medical disclosure and I find out that he had a knee x-ray in the year before the accident. So I'm thinking, oh my goodness, I thought he had no knee problems previously. He must have had an issue. And of course the insurance company defense picked up on this. He'd also had Percocets prescribed to him in the year before the accident. These are some pretty heavy-duty analgesic painkillers. Well, if he was in such great health, why was he on perks? So I thought, okay, another wart we'll have to deal with. So we looked into this, and I'll describe for you in a minute how we were able to resolve that. As if that wasn't enough problem, the insurance company denied liability. They said, we're not at fault. Here's what happened, in fact, and you know, you can't help but feel a little bit for the insurance company, because what had happened is one of the workers of the department store was wheeling a skid of Kool-Aid jammers to put into place, and one of the cases fell off on the floor and it exploded like a bomb, and there's liquid on the floor. It's close to closing, only about 5 minutes to go, so the worker looks around, doesn't see anyone that can help him clean up the mess, so he leaves the mess, and in about a minute or less while he's away trying to find something to mop up this mess with or get someone to help him, guess what? Tom comes around the corner of the aisle and slips on this liquid. As it turns out, there was video which caught him doing this, which is not always true, but in this case it was helpful for reasons that I'm about to explain. But you think, you know, poor guy. I mean, he went off within seconds to try to mop up this mess, and just within a minute or less, my client comes along and, unbeknownst to him, slips on this liquid. So what was he supposed to do? And that's what the insurance company lawyer argues. Like, what was our guy supposed to do? He went to get some help really fast. So we said, well, he could, for example, have just simply waited until the store closed. It was only 5 minutes, and by then the customers would be out and he could have got help. He could have done it leisurely. Or he could have wheeled the skid onto the liquid so that it wouldn't be exposed to someone. There was other things that he could have done. But liability was disputed. Another complication that we ran into is while my client was off work for a period of in excess of a year, he received benefits through his disability insurance company through the hospital. And the insurance company wanted to take credit for those insurance benefits that were received. And we said, nothing doing it, you don't get any credit for that. And the insurance company argued, well, then you're going to be paid double for the time he's off work, because you're asking us as an insurance company to pay those lost wages, but he's already got it from his own insurance company. And we were able to deal with that successfully and give no credit to the insurance carrier, because that disability insurance was something that our client had to pay for every week with his paycheck deduction, so it was not free. And he could have paid thousands of dollars over the previous number of years for that coverage, which he'd had ever since he'd been employed in the hospital. So there's no double recovery. Now, lastly, we were arguing that there was going to be a future income loss. Even though our client had returned to work and had done so successfully, Tom did return to a lighter job within the hospital. And the medical evidence suggested very strongly that Tom would need probably surgery at some point on his knee in the future because of his fracture. The joint was injured and arthritis had set into that joint. And for anyone who has had arthritis, you know that it's a degenerative, progressive disease. It gets worse with time. Now, would Tom need future surgery while he was still going to be working? Who knew? The doctors really couldn't say when that would be, but it's possible that he would have had more time lost from work or even have to face an early retirement. Well, here's what we found out about Tom's need for perks and his knee x-ray. As it turned out, he was working in the hospital and he was at a desk and he got up from his chair rather abruptly and hit his knee on the edge of the chair. And you know how sometimes if you've ever hit your thumb with a hammer and you scream out in pain because of the intensity, that's what he did. One of the nurses close to his desk said, "You better go down to x-ray right away and see how badly you've hurt your knee." So he didn't want to do that, but it was hospital protocol. So he went and had a knee x-ray, and as it turned out, he was fine. He didn't miss any time from work, but the x-ray didn't look real good until we were able to come up with an explanation. All right, so how did we fare on the perks? Why was he taking these heavy analgesic painkillers, Percocets, in the year before the accident? Well, it turns out that he'd had a kidney issue. He had kidney stones, and thank the Lord I've never had kidney stones, but I understand that passing a kidney stone can be painful like childbirth. And he was on perks because he had a kidney problem, which had cleared up. But it wasn't for any general pain disorder, it was because of a kidney stone. So in a case, no matter how it happens, there's always this contest of wills and perspectives and views of differing positions, and that's called the adversarial process, where there will be two different perspectives. Lawyers or sometimes insurance adjusters will put forward their view of the world, and we as plaintiff personal injury lawyers will give ours and hopefully come to an acceptable compromise at the end of the day. The client's credibility is very important, so you've got to be sure that what your client is telling you is true. And I was just really glad that he had an explanation for why his previous health involved some chronic pain and that his knee really was okay. But you know, unfortunately, what sometimes happens is that people don't heal the way they're supposed to heal. Everyone's different. Everyone's healing process is different. And the normal physiology of a knee fracture or any given injury is a course of weeks or months over which near full-time recovery will be experienced, but not always. And sometimes people don't go on to pre-injury status. They are left with some permanent partial disability at the end of the day. And sometimes they develop something called chronic pain. And this is a general pain disorder that just doesn't go away. And it generally will develop after about a 6-month period following the injury and can last a lifetime. And that's what happened with Tom. He was in tremendous pain. He was a very emotional guy. He felt his pain very keenly, perhaps more than some, but that wasn't his problem. But he became very depressed. He had a bit of an anger management issue, and he became very angry at the world, and he took it out on his family, which really wasn't fair, and it made him feel dreadful that he would do that, but he just couldn't seem to control it. So not only physically was he disabled, emotionally he was as well. So he was able to be assisted by a psychologist, and mental health therapy assisted him, and he was able to move on with life. It's interesting, as we viewed the video of our fellow falling, because the lawyer argued that the liquid was brightly colored and should have been clearly seen as our guy rounded the corner. But interestingly, as we viewed the video for the first time, we were able to recognize that the liquid was not easy to view at all, even though it was quite brightly colored apparently. However, a very brightly colored sign that appeared in the same video was very easy to see. In other words, those bright colors were very evident, but the alleged bright colors of the liquid were not. So the video, instead of hurting us, actually helped us a great deal. When there is a case involving negligence, there is a standard of care that is owed, which is breached. And when that standard of care is breached and damages result, there is what lawyers refer to as the tort of negligence. So our case was framed on the theory that the occupier of the department store was negligent in not maintaining a safe condition. We argued as well that our client Tom suffered a reduction in his ability to earn future income, because if he ever lost his job at the hospital because of downsizing, he would have a very difficult time competing in the workforce with other uninjured, often younger people applying for the same job. And part of the settlement that we were able to achieve recognized this reduction in his ability to be competitive in the labor market. And there's cases that have considered this loss of what lawyers will refer to as loss of competitive advantage. And the court, even though it's a difficult exercise to value what that claim is worth, will routinely award damages for it. We had valued Tom's injuries in accordance with a case which is frequently cited in Ontario based on chronic pain at a figure of around $88,000. Now, when the settlement negotiations began, in response to the claim which we advanced of $262,000, the defense countered with $100,000. Their offer went to $112,500, went up to $126,000, and eventually we compromised the claim at $142,500. So Tom lived happily ever after. Well, no, not exactly, because he still was facing additional knee surgery at some point in the future. He probably was going to miss more time from work. He probably would have to retire early. So every case has its takeaways, and here's 3 takeaways with respect to our claim. The first is that when settling a personal injury claim, a lawyer always has to keep in mind their client's medical future. Physicians call this a prognosis. And when a joint is injured, the internal structure can be damaged, which exposes the joint to future arthritis, which is a term used to mean any disorder that affects joints. If you've experienced arthritis, you'll know that can include joint pain, stiffness, swelling, reduced range of motion, reduced strength, etc. It's a degenerative process. So when we have a client who has a joint that's been injured, we're very interested to know what the future holds in store for them. Secondly, surveillance can make or break a case. In this case, it greatly assisted us. I've had other cases that have been destroyed as a result of surveillance, where I realized that my client was less than truthful to me. So surveillance can be a two-edged sword. And thirdly, and this is something that is important to keep in mind for someone like me dealing with these cases, it's really important to understand the pathology of injuries, physiology, and anatomy. If we don't understand the medical process, it's very difficult for us to know what questions to ask a medical expert to get a report which will help us in the quantification of a claim. And in this situation, we knew that because our client had injured their knee, that their gait had changed. The way they walked, the way they ambulated was different, and that our client would likely be assisted by not only compression stockings because he had edema or swelling in his lower leg. The circulation was off, that's why there was swelling. The second takeaway is that surveillance can make or break a case. I've had some cases that have been absolutely destroyed as a result of surveillance because they've caught my client saying or doing something that they say was impossible. Perhaps it was them running when they said they could no longer run, or it was taking the garbage out to the end of the driveway, carrying a heavy bag when they say they couldn't do any heavy lifting. But surveillance is a two-edged sword, and in this case it really helped our case because it was plain to see, pun intended, that this liquid on the ground was not easy to see at all for someone, even though it was brightly colored because of in part, the color of the floor on which it fell. Lastly, we've come to learn that the ability of someone to walk the same way they used to after injuring their lower extremity, like an ankle or a knee, is very much affected and is correctable through something called custom orthotics. Because Tom's lower leg swelled, it could also be assisted through something called compression stockings. Unfortunately, they're very expensive. They can cost over $100 each, requiring at least 6 pairs a year, and you need them for life. Custom orthotics that you put into your shoes, $400 or $500. They'll last for perhaps 3 years. Having custom-built orthopedic footwear is also important. And we were able to establish that Tom needed all of these things to help him with his change in ambulation because of his deteriorating knee. And over a lifetime, over decades, that can add up to a significant amount of money.